So a question I get surprisingly often is, can you leave your home to one child but not the other? And the short answer in Georgia is yes, you can, but how you do it matters a lot. Hi, I'm Jim Fletcher, Georgia estate planning attorney. So under Georgia law, you are generally free to leave your property to whomever you choose, including leaving a home to one child and not another. There's no requirement that you divide assets equally among your children. That said, unequal distributions are one of the most common sources of family conflict and legal challenges, so planning carefully is critical. Let's start with what happens if you do nothing special. If you pass away without a will or a trust, Georgia's intestacy laws control, and in that case, your children would inherit equally if they are your sole heirs. You don't get to choose which child receives the home. So if your intention is to leave the house to only one child, you must have a properly drafted estate plan. Now let's talk about intentional unequal planning. Imagine a common scenario. One child has lived in the home for years, helped care for you, contributed to maintenance and expenses, and another child lives out of state and has no involvement with the property. It's very reasonable for a parent to want the child who stayed and helped to receive the home. You can accomplish this in a will or a trust by clearly stating that the home goes to one child and not the other. Clarity is key. Vague language is where a problem starts. If the document is unclear, that's when disputes and lawsuits happen. However, simply leaving the house to one child doesn't mean the planning is done. You need to consider whether the other child is receiving something else. Sometimes the issue isn't the unequal distribution, but the surprise. Parents often choose to balance things out by leaving other assets like life insurance or investment accounts to the child who is not receiving the home. Another important consideration is creditor and tax planning. If you leave the home outright to one child, it becomes their asset personally. That exposes their inheritance to their creditors, divorce, or financial issues. In some cases, placing the home into a trust with asset protection features can offer better risk protection and smoother administration. You also need to think about timing. Do you want the child to receive the home outright at your death, or do you want them to live in it for a period of time before full ownership transfers? Georgia law allows you to structure that, but it needs to be done correctly. Finally, let's talk about estate plan challenges. In Georgia, a child can't successfully contest a will just because they think it's unfair. But unequal distributions are more likely to lead to a claim of undue influence or lack of capacity. That's why proper drafting, documentation, clear intent, and working with an experienced estate planning attorney matters. Leaving a home to one child and not the other is legal in Georgia, but doing it the wrong way can create family tension, court battles, and outcomes you never intended. Good estate planning isn't just about what you leave, it's about making sure your wishes are carried out with as little conflict as possible. Do you need help with your estate planning? I'll make it simple.